Good morning. I'm doing an overview of the Supreme Court right now. On Thursday, I'm going to be putting a document up on what's called collaborations. So when you go to the Canvas website, over on your left-hand side where it has assignments and quizzes and announcements and all of those things, down near the bottom, it says collaborations. And there will be a list of 63 different Supreme Court cases. I need you to go into that document. All of you should be able to open it and get into it and put your name on one court case. And then once you go to, I'll give you the instructions, but the website is OYEZ, which is OYEZ, oyez.org, which is the Supreme Court's website. You will look up that case. You will go to that website, look up that case, and then put a summary next to the name of the case so that everyone can now share in this collaborative document. And that is your part of this document. So I'll go into that when we do the assignment. But right now we're looking at an overview of the Supreme Court. So these are some of our that vocabulary that you need to know about the Supreme Court. So there's the Amicus Curiae briefs, which ami means friend. So they're a legal brief submitted by a friend of the court, Curiae meaning court. So friend of the court briefs. A brief is not a form of underwear. It is actually a paper that's a legal paper that's submitted to a court. And it is the purpose of raising additional points of view. Most of the time, a Supreme Court case is not tried by lawyers. They read and read and read the briefs, the papers that have been submitted, and then they make rulings and they discuss it together on the case. Original jurisdiction. Remember, a jurisdiction is a geographic area over which a court has power. So the Supreme Court is all 50 states and, strangely enough, the high seas, because, if there's a pirate out there or pirating, they have control over that. So original jurisdiction is the jurisdiction of courts that hear a case first, usually in a trial. This usually does not happen in the Supreme Court. Piracy is one, treason is another. Sometimes an original court case comes if it has to do with us and another country, or us and an ambassador, or that was covered in the crash course that you saw before. Appellate jurisdiction. The root word of this is to appeal. The jurisdiction of courts that hear cases brought to them from lower courts must have evidence of mistakes or that their rights were violated. You just can't go to the Supreme Court and go, I don't like how they decided my fate. I want this heard again. You have to have proof that your rights were violated or that mistakes were made. And that's how you appeal on. That is the standing to sue, standing. And then we have district courts. These are the lowest federal courts where federal cases begin and where trials are held. We are in District 10, and the district courts all do this. Then there's courts of appeals. That's authority to review decisions by federal district courts. So the district courts hear cases the first time. They are cases where laws have been violated in more than one state. So they'll often hear anything that's happened within District 10, if any of those states have had cases. If it goes more than that, they have to decide which district the case is going to be heard in. But so drug deals, things that cross our borders, things that cross state borders, human trafficking, any bank robbery case, any kidnapping case. These are all federal courts where they have the original jurisdiction and they hear the thing for the first time. But the courts of appeal are the state violated your rights. And so then you go to the federal appellate court before you go to the Supreme Court. Senatorial Courtesy. This is a long-standing, unwritten, unofficial, and non-binding political custom. It's just the way we do things, but we don't have to do them that way. It's not set down in law. It's just a custom. Describing the custom of the president to appoint federal judges according to recommendations of senators from that state. Then there's the Solicitor General, the law officer directly below the Attorney General, who argues cases before the Supreme Court. Then we have stare decisis. So stare meaning stand, and decisis is decision. So basically, it's a doctrine that states courts have precedent during the litigation of a current case. Let the decision stand. The appellate court agrees with the lower court. Now, 65% of the time, this is what the Supreme Court decides, or the federal appellate courts. They say, no mistake was made. It looked like maybe a mistake was made, and you thought there was one, but no, they made the right decision. So let or stand, stare, let the decision stand, the decisis stand. Precedent, the past issues decided in courts. It sets a standard for all other similar cases. And then we have judicial review. This is the ability for the U.S. Supreme Court of the constitutional validity of a legislative act or executive order or presidential acts. So they can say this law by Congress is illegal. It's unconstitutional. Remember, that's their superpower. Throw it out. And it throws out. It's gone. Judicial restraint, the idea of judges limiting the use of their power to a literal word-by-word interpretation of what the Constitution says. It is a conservative view, definitely. Judicial activism, the idea of a ruling creating new policy based on constitutional penumbra. Shadows, a penumbra is a shadow or a hint of rights. It is a liberal view because it is their judicial restraint is very conservative. We can't do anything unless the Constitution specifically says what we can do. Judicial activism is, yeah, but it was written over 200 years ago, 250 years ago, almost at this time. And so how would they know what we need to do? And things have changed and people have changed. So if the right is hinted at the Constitution, we can take that right. So a lot of new cases these days are decided on that way. So here are the questions. List 3 regular participants of the judicial system and the roles they play. So litigants, that's the plaintiff, the prosecution, bringing complaints, plaintiff complaints against defendants, the accused, the people defending themselves. So there's plaintiffs and defendants. And the first name in any court case is the plaintiff. So this name, Brown, Mr. Brown was bringing the case against the Board of Education of Topeka, Kansas. Brown versus the board. He was complaining that they wouldn't let his little girl go to her neighborhood school, which was all white, and she was African American. So he was the plaintiff. He was the one who had gotten an injury, and he was complaining against the school board of Topeka, Kansas. And then attorneys argue on behalf of the litigants, both sides, and groups. Special interest groups tend to be interested in the long-term legislative implications of court cases. So rather than the litigants themselves, it's not so much the people, it is the standard that is set, the precedent that is set. They try to influence court decisions. Some groups that use the court system this way have been the NAACP, the NRA, the ACLU, et cetera, et cetera. Complete the following table on the structure of the federal court system. So there are 94 district courts. There are 677 at the moment number of judges. This varies between 650 and 680, depending on the needs of that particular district. And the jurisdiction is regions of the USA. There are 12 different regions. Courts of appeal. There are 13, so all 12 districts plus the Supreme Court. And 179 judges and the regions of the USA. Oh, not with the Supreme Court. There's 13 courts of appeal because there's also one that is in the District of Columbia. And then Supreme Court, there's one, just one. There's 9 judges. When it was first started, they had 6, but they soon stopped that because they would have 3 and 3 make decisions. And when you'd have a split decision, then it wasn't definite, the decision. So it has to be an uneven number. Present a demographic view of the typical federal judge. So usually white male, 50s to 60s, Protestant, previously a lower judge, though in the last 10 years there have been more females, and we have had one African American, just one, and 2 Hispanic judges. So what is the function of Amicus Curiae briefs? Attempt to influence the court's decision, raise additional points of view, and present information not contained in the briefs of the attorneys. So a different point of view on the same case. What is the difference between a majority opinion, a dissenting opinion, and a concurring opinion? So the majority opinion is a court opinion reflecting the views of the majority of so at least 5 of the 9. This is a majority. Dissenting opinion, opinion disagreeing with the majority of a decision in a ruling. So it can be anywhere from 1 to 4 judges can be the dissenting or the losers in the decision. Concurring, assigned opinion which 1 or more members agree with the majority view, but for a different reason. So they might put this in there saying, yeah, I decided to rule the same way he did, but for a different reason. And it's really important that we write these down because, for instance, in Plessy v. Ferguson, 1896, when they first decided it was okay to segregate, 1896, separate but equal, there was one guy who said, no, it isn't okay. One judge who wrote a dissenting opinion, and his opinion was read out 50 years later, 60 years later, when they did Brown versus the board. They used his dissenting opinion to justify switching that over. No, we cannot segregate. It's wrong. And so they used his opinion. What is the difference between stare decisis and precedent? Stare decisis is the appellate court siding with the lower court's decision. No mistake was made. And precedent is stating a policy. Sometimes precedents can be new, where the court decides the law should take us, setting a new standard. Explain the difference between judicial activism and judicial restraint. This will be on your test. Judicial activism is a philosophy of judicial decision-making whereby judges allow mainly their personal views about public policy to guide their decisions. They are bold policymaking. They use shadows of rights to be active. Judicial restraint is a judicial deference to the views of the legislatures and adherence to strict jurisdictional standards, looking strictly into the words of the Constitution to interpret its meaning. Okay. That basically is the end of this lecture. You will need to review this when we do our review for this. We will have a test on the Supreme Court, a quiz on the Supreme Court, and it's mostly based on what's in this lecture and then some of the Supreme Court cases that we will be doing on Thursday, starting on Thursday and that next week. Okay, thanks. I hope everything's going well and that you're doing well and your families are well. And just remember, I'm here if you need to contact me. I'm always checking my email between 11 and 2 every day. And so shoot me off an email or try and get a hold of me that way. I try to get right back to you. Good luck.